Minnesota Senate COVID-19 Response Working Group. Again, the members are Senators Benson, Chamberlain, Champion, Cohen, Kent, Marty, Pratt, Rosen, and I. And today we'll be joined by Senators Limmer and Latz. Transparency has been challenging through this time of COVID-19 and trying to keep the public and everybody that's interested in the loop. And this is our attempt to do that. Tomorrow we have another COVID bill that will be on the floor that has a number of components to it. And we wanted to take this time to explain the bill to those that are interested. And so with that, I want to start with Senator Benson on your portion of the explanation.
Hi, good afternoon, everyone. There are several significant provisions to this legislation. So sections 10, 11, and 12 are temporary waivers of authority, giving the MDH commissioner significant powers during this peacetime transition, including and significantly the ability to add licensed hospital and nursing home beds without having to go through a moratorium exception process. Additional authorities granted under that section: testing for uninsured individuals who need COVID testing, and then payment for that testing, as well as payment for the related doctor's appointment. That doesn't apply to other diagnoses that might occur during that office visit, but we are paying for testing and the doctor's appointments. Significant waivers of things like visits to birthing centers, tattoo parlors, oversight of doulas. Keep in mind, all of these things are waived except for the health and safety requirements. So if there's a question about health and safety, the commissioner still will meet those requirements, but this gives flexibility to the staff so that they can focus on COVID response instead of sort of the normal and ordinary provisions and inspections. Again, we move to temporary alternative healthcare facilities. Importantly, we also allow medical assistants to pay for care in those temporary facilities, and this will send a signal then to the private sector that they can reimburse for care in those temporary alternative facilities. Section 14, telemedicine coverage, it aligns the provisions under 62A with those under medical assistance. And this was shown to the Council on Health Plans, and they have not made me aware of objections after we made modifications to the language. So they have seen this language and have raised no further objections. Under Section 15, we have licensed respiratory care therapists for telemedicine. This way, respiratory therapists remaining under the supervision of a licensed physician could provide respiratory therapy, check in with their clients, and provide that care via telemedicine. And with that, Mr. Chair, I believe Mr. Dave Lee, Director of Public Health and Human Services from Carleton County, did have comments that he would like to share.
Thank you, Senator. My name is Dave Lee. I'm Chair of the State Advisory Council on Mental Health and Director of Public Health and Human Services for Carleton County. COVID-19 has forced us to look for opportunities to innovate rapidly. We are using technology like never before to deliver important services. Minnesota IT has partnered with Minnesota counties, tribal nations, mental health centers, local law enforcement, and schools for many years to develop our system that had 6,000 users in early March. Due to the COVID-19 response, an additional 5,000 users have been added in the last month alone. Utilization in some regions of Minnesota have seen an increase of over 2,000% in just the past 3 weeks. You have heard of PPE, or personal protective equipment. Telepresence offers us PPT, personal protective technology. Unfortunately, our telepresence system in Minnesota is at the breaking point. Minnesota's system is designed for large-scale telemedicine-grade networks. Leading medical systems have chosen this technology, including the Mayo Clinic. Due to its security, the U.S. Department of Defense also utilizes the system for worldwide communications. Our state leads the nation in developing a telepresence system that includes public-private partnerships, multidisciplinary approaches, and a focus on the future. If we don't invest in ongoing innovation, we may find ourselves reliving our past mistakes, revisiting the lessons we learned when we saw the unguided development of multiple electronic health record systems. We are at that fork in the road right now. With federal dollars available, now is our opportunity. I strongly encourage a $2 million investment to allow us to provide the services that are so desperately needed, both during the COVID-19 crisis and beyond. This investment would be relatively small. However, the return on investment could be very high. Thank you.
Thank you. And Mr. Chair, for members of the committee, we do have Mr. Matt Burdick and Dave Greenman from the Department of Human Services if there needs to be clarification.
Are there questions? And I don't have the screen to read that, so
And
Senator, if you could do that part.
Yep, I am not seeing messages on the chat. Okay, I'm getting a message. Nobody's raised their hand. So if there's no further discussion from members, Senator Gazelka, that completes my portion of this language.
Thank you, Senator Benson. Next on the agenda, we have Judiciary and Public Safety with Senator Limmer. Senator Limmer, could you take us through that portion of the bill? You're on mute, Senator Limmer.
I'm vocal now. Thank you, Senator Gazelka. I'll be asking Senate Council to walk us through this portion of the bill that falls under our jurisdiction. Ms. Primo, are you on board?
Mr. Chair and members, I will review the 5 judiciary provisions included in the revisor document 20-8345. And for your reference, these sections are sections 2, 16, 17, and 18 in Article 1, and Section 3 in Article 2. I'll also highlight the page and line numbers as I go through it. The first section begins at page 2, line 25. Current law requires a will to be in writing, signed by the testator or another individual at their direction, and signed by 2 witnesses. This section provides that during the period of March 13th, 2020 through February 15th, 2021, if a decedent does not perfectly meet the requirements under current law, the writing may still be treated as if it has been executed properly if there is clear and convincing evidence that the decedent intended for the writing to constitute the will or a modification of their will. The next section is section 16 on page 11, line 14. This section suspends the running of statutorily imposed deadlines governing proceedings in district and appellate courts beginning March 13th, 2020, and for 60 days following the end of the peacetime emergency declaration or February 15th, 2021, whichever is earlier. This section does not prevent a court from holding a hearing or requiring an appearance if the judge determines that public or personal safety reasons or other emergency matters require specific action in that case. The next section is section 17 at page 12, line 1. This provision modifies the timeline for filing a motion to contest a cost of living adjustment for court-ordered child support. Under current law, court-ordered child support is subject to a COLA effective May 1st, 2020, and that's the date by which a motion to contest that COLA is required to be filed by. So this section extends the filing deadline for the motion to June 30th, 2020, but also provides an additional extension up to October 31st, 2020, if the child support obligor is unable to file the motion in a timely manner due to reasons related to COVID-19. Any adjustment would be effective May 1st, 2020 under this language. So the next section is section 18. It begins at page 12, line 16. Under current law, at least one party is required to appear in person before a local registrar if they're applying for a civil marriage license. This section provides an exemption from that in-person requirement and also authorizes each local registrar to develop and implement procedures to accept marriage licenses by mail, fax, or electronic filing, and also examine the parties upon oath remotely. An examination of the parties upon oath may include contemporaneous video or audio transmission, or could also include a receipt of a verified statement signed by both parties. The last section is in Article 2, Section 3, which begins on page 16, line 26. This language is from Senate File 3616, which was heard and passed by the Senate Judiciary Committee on March 3rd, 2020. It provides specific authorization to coroners and medical examiners to access data on the Criminal Justice Data Communications Network in order to identify a deceased person. That concludes my review of the 5 judiciary sections, but I am willing to stand for any questions the members.
Are there any questions for Ms. Primo or Senator Limmer? I can't see the hands. I haven't figured that out
Mr.
yet.
Chairman?
Yes.
Yeah, this is Dick Cohen. If I can just ask maybe Senator Limmer, and I think Senator Lass is also on, and Ms. Primo. Were these changes, I missed, Ms. Primo, I missed your introductory comment. Were these changes presented by the Supreme Court, by the chief, or what was the genesis of this, and who's okayed them or taken a look at them?
Senator Limmer, can you answer that?
Yes, we concluded with Janet Marshall in the Supreme Court, as well as the Chief Justice. She did weigh in from time to time. She asked the legislature to be involved in this, recognizing separation of powers.
24 days. Senator Cohen, anything else?
Just quickly, Senator Limmer, and was it just simply the chief, or was the council involved at all in terms of some of the chief judges?
I believe that the council was advised. I didn't speak with them directly. We were getting our communication from the chief as well as from the council through Janet Marshall.
Okay, all right, thank you.
Any other questions? for
Sorry,
Senator?
Gazelka?
Yes.
Oh, I'm sorry. If there's no other questions, we do have some brief testifiers that would like to
Yes.
chip in on this. Mr. Brian Lake from the Minnesota State Bar Association is waiting.
Mr. Lake, go ahead.
Thank you, Mr. Chair. I'll just be very brief. First, I'll just cover the first 2 things that that Ms. Primo covered. The suspension of deadlines, statutory deadlines in the courts. So I should note as well, Senator Limmer did, I'm representing the Minnesota State Bar Association today. So in the view of the bar, we think that suspending the deadlines is a very necessary, important thing to do right now to help the courts manage the unprecedented pressures on their calendars, but do so in a way that preserves rights and provides for hearings still immediately if there's an urgent matter. So we think it's a very good and very necessary proposal, and we're very supportive of it. The second thing Ms. Primo mentioned was the harmless errors provision for will execution. So the problems we're seeing out there right now are folks doing their own wills, using do-it-yourself software or some other method to write their own wills, and trying to handle their own will executions, their own will signings. Due to the pandemic, folks are not wanting to be in the same room with a lot of other people. They're not necessarily wanting to travel and be in close quarters. So they're resorting, we've heard anecdotally, to some unconventional witnessing methods like using FaceTime or other things for will witnessing that our courts just simply haven't considered yet. So it's kind of unknown how they're going to react. If those kinds of wills are found valid, the testator's wishes aren't going to be followed. What we're proposing here is the harmless error standard. It comes from the Uniform Probate Code. It's been adopted in several other states. And what it does essentially is keep our statutory requirements that Ms. Primo mentioned of having the will be in writing, have it be signed by the testator, and have two witnesses, but still give the court a little bit of flexibility if the execution was handled a little bit, imperfectly, and allow the court to salvage a will that would otherwise be invalidated, but only when there is clear and convincing evidence of the testator standard, which is the highest standard in a civil matter. So again, another proposal that we think is really important, and be happy to answer any questions about that if there are any.
Thank you, Mr. Lake. Any questions for Mr. Lake? All right, Senator Limmer, any other comments?
Yes, there are. Miss Rebecca Holshoe from Hennepin County Attorney's Office.
Go ahead, Ms. Holshoe.
Good afternoon, Mr. Chair and Senators. My name is Becca Holshoe. I'm appearing on behalf of Hennepin County and the Director of Licensing. Hennepin County is supportive of the language proposed in this legislation that allows local registrars flexibility in issuing marriage licenses during the pandemic. It strikes a balance of permitting access to the license while ensuring that local registrars conduct the due diligence that's required to ensure the proposed marriage is legal. There is significant demand for marriage licenses even during the current emergency. As you know, Section 51708 requires a local registrar to examine the parties upon oath to determine whether the marriage is legal. This is an important function that's ordinarily performed at the service counter with both parties present. Current law does allow one party to submit a notarized statement instead if that party is unable to appear. Consistent with this legislation, Hennepin has developed two options for the remote issuance of marriage licenses during the pandemic. Under the first option, applicants would complete and submit a marriage license application. Each applicant would also complete a written verification to supplement the application. This verification is a list of written questions Hennepin developed in order to replace the due diligence inquiry that's ordinarily performed at the counter. Each applicant must swear or affirm that the statements on the verification are true and correct in front of a notary. Upon receipt of the application and verifications, the registrar would then issue a license. Under the second option, the couple would still complete and submit a marriage license application. They would then call to schedule an online video conference with registrar staff. Through that conference, staff will ask the parties for proof of identification and conduct the due diligence inquiry. The license would then be issued. Thank you for your consideration of this provision, and I'd be happy to answer any questions.
Senator Latz, I believe you have a question for Ms. Holshoe. You're on mute, Senator Latz.
Yep, thank you. It's not directly for Ms. Holshoe. I just was wondering what your plan is with regard to testimony from persons that have submitted written comments, and when we'll have an opportunity to make our own comments or about those kinds of things.
What did you do with my ball?
So Senator Limmer, do you have for your portion and testifiers, are you, do you have a plan for that?
Well, I was going to make mention that there is written testimony. I would imagine that most of you do not have that, but we can get that to you before tomorrow's vote. I know that Joel Carlson from, I believe he's representing the Battered Women organization in this bill. And there are others, in particular, one who is speaking in favor of private citizen, who is speaking in favor of the COLA language that we have in this bill. And I believe there may be some others. I don't have their names in front of us, but we can get that to all the members of the Senate either tonight or tomorrow morning before the vote.
Senator Latz, do you have somebody in particular that might be in opposition or you might feel needs to be read now?
Well, Mr. Chairman, this is my first time with your working group, so I'll just ask questions that perhaps out of ignorance. But my understanding was that written testimony that was submitted for the purpose of consideration by this working group was to have been distributed to the members of the working group prior to the meeting. I have not received anything. Did I miss something in the process? And I know there were a couple of people that had requested the opportunity to testify on the judiciary portion of the bill, not related to what's in the bill, but what they think should have been in the bill. And I've not been given any information about whether they will be allowed to testify, except that I believe they got emails back from the staff person in charge of this that said, we have a lot of people who want to testify. You probably won't be able to, but I haven't heard anything else.
Yeah, Senator Latz, this is the first time we've done it this way. It wasn't really about a bill in the past. It was more of a working group to work through issues. And so, Senator Limmer, I don't know if you have any comments on your portion here. I don't have any additional comments.
Well, Mr. Chair, I do not have the comments in my possession right now from other people who would wish to offer written testimony. As for comments about what's not in the bill, I was given instruction that we were to cover what was agreed upon by the 4 caucuses. And that's what we're prepared for today, with the exception of the written testimony. I don't have any other comment to make regarding that at this time.
Yeah, and Senator Latz and everybody here that's participating, it's part of the reason we're trying to figure out how do we get back to whatever the new normal is. This is extraordinary times where the 4 leaders have agreed that we won't move anything forward unless, first of all, 4 people from each side have been working with their particular issues, and then that's brought to the 4 leaders, and the 4 leaders have to agree as well, and it's focused on COVID-19, but it is not perfect, and that's why the sooner we get back to some sort of new normal, I think the better.
Senators, there are the documents posted with the hearing notice for this working group, and that's how we've been operating. So you can find all the testimony that's been submitted written with the hearing notice post.
Okay, Mr. Chairman.
Yes, Senator Latz.
I'm not going to be on the Senate floor tomorrow to make a testimony or a presentation as to what I think should have been in the bill. That is not, that's lacking. That is specifically COVID related. So this may be my only opportunity to make any public comments in connection with several of those pieces. So if you will let me know when that would be appropriate, if you want to wait until everyone else has had an opportunity to make the presentation about the contents of the bill, and then I can add a few thoughts after that, or if you want to do it section by section, whatever is your preference, I'm happy to do.
Yeah, Senator Latz, let's do it when Senator Limmer has finished up his section. And just for the group, I've been on Zoom conference calls all day in this room that has a beautiful background for you, and my battery literally isn't staying charged up. And so if I suddenly am blank and not here, I didn't hang up on anybody. So Senator Limmer, why don't you proceed? Ms. Holshoe, do you have any other comments? Otherwise, we'll move to Sean Wilson.
Nothing further. Thank you.
All right, let's move to Sean Wilson, Hennepin County Medical Examiner's Office.
Mr. Chair and members, thank you for your time. My name is Sean Wilson. I'm the Operations Manager for the Hennepin County Medical Examiner's Office, which serves Hennepin, Dakota, and Scott counties. While I'm here before you today representing my agency, there is widespread support for this provision from the medical examiner and law enforcement community, and we thank you for including this important action in the COVID bill. The importance of this legislation cannot be understated as we potentially plan for thousands of Minnesotans dying from COVID-19 alone and from vulnerable populations. The overwhelming majority of identifications of deceased persons are not in support of criminal investigations. They are to meet statutory requirements of the medical examiner to identify deceased persons and provide closures to their families. Oh, hold on one second. I see you asked me to start my video here. Sorry, I thought you guys had me stopped. So. There we go. So to continue, this bill will allow medical examiners to rapidly identify deceased persons using digital fingerprint technology that under current law requires manual paper processes involving multiple agencies. Other states within our FEMA region are relying on the FBI evidence response teams for this type of service in response to COVID-19, and they cannot or will not be able to meet the demand. This action will not grant us new or expanded access to the data. It simply makes the process more efficient and allows positive identifications to be made in seconds rather than days. The results are that families would receive their closure faster, and the medical examiners and coroners would not be dependent on external agencies. We worked in close consultation with the Minnesota BCA on this effort, and the language before you reflects their input. I'll leave you with an analogy that I've left the committees already. This bill does not create a new road for us. We travel it every day. It's the difference between taking a horse and buggy down that road or taking a Tesla. One is older and cumbersome. The other is modern, clean, efficient, and lightning fast. And with that, I thank you for your time, and I'll stand for any questions.
Any questions for Mr. Wilson? All right, I don't see any, so let's, Senator Latz, let's move to your comments, and then Senator Limmer, if you have anything final to say, go ahead.
Thank you, Mr. Chairman. As you can see, we're not in the formal committee chambers, so I am eating at my desk and no one can do anything about it. A couple of things. First of all, thanks for the opportunity to make a few comments. I like the process that we have been doing as best as we can to gain consensus among the leads and the leadership and the stakeholders. But I have felt like we've run into some roadblocks where there seems to be a large degree of stakeholder consensus, but we haven't been able to get everyone in the legislature in terms of leadership positions on board. And I wanted to highlight a few of those anyway. One was the Chief Justice's request relating to speedy jury trial demands. And right now, she had requested that we specifically authorize speedy trial demands to be delayed. One might have thought there would be some objection from the defense bar on a request like that, but there was none. And I think part of the safety concern is pretty obvious. You know, if someone can force a trial, you've got all sorts of logistical issues tied into actually seating a jury and being in a courtroom to conduct examinations, then having a jury deliberate. But there'd be some real question whether or not you could have a jury trial in today's environment where a jury would feel comfortable deliberating in a room, even if they're 6 feet apart, each of them wondering who next to them might have been exposed and might be infecting others. The deliberation would be rushed probably and not deliberate. So I think, you know, the courts will have to sort this out on their own, I guess, but I wish we had had an opportunity to have a little more thorough conversation about that request from the Chief Justice. The second half of her request is in the bill relating to the tolling of other statutory deadlines and statutes of limitations, which I think is a very good piece to include in the bill, and I appreciate that it's there. There is another suggestion relating to the prisoners in the Department of Corrections in our state prisons. And while the local jails have had sufficient flexibility with their county attorneys and their other prosecuting attorneys and administrators to do early release of nonviolent prisoners that can reduce the likelihood of there being a mass outbreak in local jails, the state prisons don't have the same level of flexibility. So the new Department of Correction ombuds person, or as he's calling himself, the ombuds, Mark Hasse, had submitted a specific legislative request that a statute be passed, even on a temporary basis, to give the Commissioner of Corrections authority in the case of an epidemic of any infectious or contagious disease likely to spread throughout the facilities, that they be able to place inmates on supervised release within 180 days of their projected or supervised release date and determine eligibility and appeal process for release under this section. It was intended to cover those who are in custody on nonviolent offenses that are within 6 months of their expected release date anyway, and it would still be put on supervised release, for example, on electronic monitoring or something like that, but it could help reduce the population in the prisons for their own safety and for the safety of the other prisoners and our correction staff, the guards who are coming into direct contact with the prisoners. So I was quite disappointed that this proposal was not included in this. We are going to see, we're already starting to see some evidence of an outbreak in the Moose Lake prison. And I would hate to think that because we didn't move quickly enough or give the commissioner adequate authority to move quickly to reduce the prison population, that we're going to have spreading infections throughout the prisons in the same way that we have them now in a number of nursing homes. The last piece that I think should have been in the bill has to do with driver's license situations where people are under suspension, either because they failed to appear in court or to pay a fine, they had their licenses suspended, or because they were convicted of driving after suspension and are suspended, or driving after revocation and are now suspended. So not specific public safety risks, but they don't have lawful authority now to drive on the highways, which is to say their only alternative, at least if they live in areas where there is mass transit, is to go and be more risky to them and to other passengers on our mass transit systems, on the light rail and on the buses. We saw in New York, 41 transit authority employees have died from COVID. And so the transit system is another enclosed, close quarters kind of place where the infection could be easily spread. And the proposal was to automatically reinstate the driving privileges for this limited category, non-risky category of drivers for a period of 1 year so that they can still go to work if they are in essential services. And I would surmise to say that many of the people who are in this situation who couldn't afford to pay the reinstatement fee at the time, or didn't pay a fine, I should say, and that's why they're suspended. Many of them are in at-risk groups and low-income populations, the ones who tend to more heavily service our essential services areas, the cashiers at grocery stores, for example, those and people who are working in as service workers among vulnerable populations, in fact, as personal care attendants and so on. So there would be 33,000 Minnesotans who would qualify for this if this proposal had been adopted. They obviously can't maintain social distancing if they're on the transit systems. So they're posing a risk, even if they're asymptomatic to others, or if they're high risk for complications. The lower income population does tend to have greater instances of health problems as well, which makes them more vulnerable. And with the Metro Transit system having reduced their service by 40%, those who are still using the Metro Transit system are going to be more tightly congested into the remaining trains and buses. The other thing is, with the courts being substantially closed and the licensing bureaus being closed, it's much, much more difficult now for persons who do have suspended licenses to go in and meet the requirements for reinstatement. even if they want to go in and pay their fines at a service counter, or the licensing bureaus aren't open. So what are they supposed to do to get their license reinstated? They're stuck. And you're going to end up, frankly, with more people driving without valid privileges, which is not good for anyone. We don't want to encourage that kind of behavior. So I think that maybe next time we come around on a COVID-related bill, we'll have an opportunity to maybe have a remote or distance-based committee hearing on some of these proposals in the Senate. You know, the House authorized that on their first COVID-related session. The Senate did not do it until just past week. And we can take some public testimony on these matters because I really think they are urgent. They're COVID-related. People are at risk because we have not taken these steps. I hope that we can before we come back again for the next COVID-related floor session. Thank you, Mr. Chairman, for the opportunity to share these remarks.
Thank you, Senator Latz, and I share some of those perspectives as well. I think committee hearings, even with Zoom and the new technology, is just an important part of what we do going forward. Senator Limmer, do you have anything else that you need to say?
Yes, just to make a few comments myself. It was true that the Supreme Court did make mention of speedy trials and had a proposal early in our discussions. However, after they talked about it, after all, constitutions don't go away just because we have emergency orders. The Supreme Court withdrew their proposal on the speedy trial language. That is one thing that they did. They agree with our present language now. Regarding early release of prisoners in our state prisons, we realize that the Commissioner of Corrections has a significant amount of authority on his own right now in existing law. The early release would have changed it from a 90-day short time remaining in an incarceration setting to 180 days. Something a little different than the 90 days that the Commissioner already has. But more important is we were getting a number of calls from counties and sheriffs that manage jails and other workhouses around local communities. They were calling us hoping that we would not go in that direction because of the possibility of overcrowding, the overcrowding in light of the COVID-19 epidemic. They're concerned about inmates coming from prisons, the very prisons that COVID-19 had an outbreak in. They were very concerned. As you know, a lot of the rural areas, as well as I did receive a call from a tribal community as well, urging us not to go in that direction, simply because they didn't have the room available at that time. They didn't have medical resources, as does a prison that's got its own facilities. As for the driver license issue, this is continuing to be an issue that the legislature has not really come to full terms with. The caucus, one of the caucuses in the House was, in my opinion, flatly opposed to it. So trying to seek a four-way agreement between all caucuses was the reason why it was not included.
Senator Latz, do you have another comment?
Yeah, Mr. Chairman, thank you. Just with regard, I was unaware that the Supreme Court had withdrawn the request for the language relating to the speedy trial. So perhaps we need to make sure everyone involved in these conversations gets all the information so we can do that. I know this whole process has been challenging, but I think we need to make sure we cover that. And if I missed it and it was sent out, I apologize for that. With regard to the prison population, I know one piece of the proposal from the ombuds was to allow the release from the prisons into the local jails. And I agree that that would have been more challenging and would just have transferred the problem from one facility to another. But the other piece of the ombuds proposal was to release them directly to community supervision. And that's a different story. That doesn't put them back into another confined, overcrowded facility. It releases them back into the community. And that's the one that I was supporting and promoting, and I think we ought to give further consideration to. And it sounds like with regard to the driver's license problem, perhaps the holdup might have been the minority caucus in the House. I guess I'm not going to go too far into my thoughts on their approach to that, but I'm gratified to hear that perhaps the majority, Senator Limmer, is more open to that concept, because we have worked together on trying to find ways to get people who are unlicensed back on the road, licensed, insured, and safe. So I look forward to having some further conversation with Senator Limmer on that. Maybe we can convince the appropriate House persons to see the light on that topic. Thank you.
Senator Limmer, any closing comments?
Just one last comment about probation community release that Senator Latz had spoken of. We also did receive a comment about budgets involving probation, as well as the heavy workload that's currently being the responsibility of probation agents across the state, especially in rural areas. We were hoping this year to have a significant increase in probation funding, at least I was this year, and then the COVID-19 broke out, so we have a little bit more work to do on that, try and balance things out for our local communities. But they did make mention of that in their correspondence as well. We just have a little more work to do.
All right, well, thank you very much. Now we're going to move up to the transportation issues. I'm going to ask Senate Council to walk through these provisions. Ms. Stengel, I hope you're there, and if you could proceed.
Yes, thank you, Mr. Chair. I will be walking through the same document we've been talking about, and I'll start in Article 1 with Section 3 that starts on page 3, line 9. And this has to do with people that move to Minnesota that have a commercial driver's license or CDL from another state. Under current law, they'd have to apply for a new CDL in Minnesota within 30 days. What this provision in the bill does is extend the expiration date past 30 days until either 2 months after the emergency ends, or in this case, when a federal waiver expires. And I should back up. The federal government has waived several enforcement provisions of CDL licenses, and this is one of those. And that ends June 30th, 2020. So altogether, this would allow somebody to keep an out-of-state CDL when they live in Minnesota. Section 4 starts on page 4, line 1, and this is another CDL provision. There are several medical certificate and medical waiver provisions that a person must comply with. Again, there's a federal waiver, and this is a state law complying change. Section 5, starting on page 4, line 10, is another CDL provision. This one addresses issuing new CDLs. So what this provision does is allow a person to apply for and obtain a CDL without having to appear in person for an eye exam or for a photo. A CDL under this section will expire 2 months after the emergency ends, and at that point, the person will have to go in and have an eye exam and an in-person photo. This will immediately start for seasonal CDLs, but it will only apply to regular CDLs once the department has figured out how to safely conduct behind the wheel exam, so it's safe, so they can social distance between the driver and the examiner. And the reason for the difference is that a person with a CDL doesn't need to take the behind the road test, so that need to wait for that to start, it isn't the same for those. Sections 6 and 7, starting on page 5, line 8, require the Commissioner of Transportation and the Chair of the Met Council to submit a legislative report on the powers that they exercise during the emergency. Section 8, starting on line 6.5, extends the deadline for the Met Council to submit the Metropolitan Area Transit Finance Report from October 15, 2020 to February 15, 2021. Section 9 starts on page 6, line 9. And this has to do with the federal funding coming to the state from the CARES Act for transit. And this allows the Met Council and MnDOT to spend the funds in compliance with federal law and includes several areas that they could spend on, including things like protection equipment for operators and cleaning transit vehicles. This section also requires the commissioner and the chair to report on all expenditures made to the legislature. Moving on to Article 2, Section 1 and Article 2 starts on page 13, line 22. And this has to do with vehicle registration. As some of you may know, there was a vehicle registration task force that met during the last interim to look at ways to sort of streamline the registration. And this is largely the result of that task force. So what this will do is amend all new vehicle registrations made on or after the effective date. So all current vehicles will stay on the current system, but for new vehicles, they will be registered on a formula that is $10 plus 1.285% of the MSRP. And this is similar to what we're doing now, except for they've dropped out what's called a destination charge. So the depreciation schedule will remain the same. It decreases by 10% over 10 years. And the bottom number remains $35 for the oldest vehicles. And this section will be effective sometime in the fall or January 1st, 2021, whichever is earlier. And the earlier date could be when all of the programming changes are made in the new vehicle registration system. Section 2 of Article 2 on page 16, line 6, has to do with mistakes that are made in the data for registration. So under current law and under this bill, the Commissioner of Public Safety can't adjust the registration amount for any vehicle unless one of two exceptions applies. One is that if there was an error or omission, they can go back and correct that. And two, in some situations, a vehicle may be registered based on actual sales price. And if that's done, it needs to be adjusted to be based on MSRP. The adjusted amount is not retroactive and there's no back tax collected. So it's a going forward only adjustment. And then finally, the commissioner has to notify everybody that has their registration amount adjusted. And that's effective July 1st, 2020. And that's all I have, Mr. Chair.
Senator Cohen, I believe you have a question.
Thank you, Mr. Chairman. Ms. Dangle, does the Federal Act specify an amount for transit?
Ms. Dangle?
Mr. Chair, I think Ms. Boyd is on, and I think she'd probably have a better answer to that than I would. But I do believe there is an amount. I just don't know what it is.
I didn't catch the name, but whoever that was, they can answer Senator Cohen.
Mr. Chair and Senator Cohen, this is Krista Boyd, Senate Fiscal Analyst. The COVID bill, the federal COVID bill had $25 billion total from the Federal Transit Administration. The latest numbers I've seen for Minnesota are $308.2 million, and those are in various different grant programs, mostly urbanized areas, some for non-urbanized areas, and some for some smaller grant programs.
So Mr. Chairman, I'm not sure if this is better directed to Ms. Dangle or Ms. Boyd, but the governor had made a request in a supplemental budget for money for safety purposes for transit for the light rail system. Is there any nexus relative to COVID funding in terms of safety of passengers relative to that, where that money might be used for his supplemental request?
Ms. Boyd?
Mr. Chair and Senator Cohen, I can't answer that specifically. I know that we're still learning the guidance on the use of these funds. Obviously, most of it is COVID related, but the agencies can also use it for general operating purposes. And I don't know to what extent that money can be flexed. To the extent that other safety procedures are included in that, that would be allowable, but I just don't have a better answer for you right now.
Okay, thanks. Thank you.
Okay, anything else from Ms. Stengel or Ms. Boyd? All right, I don't see any other question. Wait, Senator Kent, do you have a question?
Thank you, Mr. Chair. Yes, I just want to address the motor vehicle tax from the task force, the work that's been done over the past several months. This has been pretty careful analysis and good work done by members of both parties, the various agencies. It is revenue neutral. And the important thing is that as we're all trying to still take care of our vehicle registration system, this will be important in helping make sure that that works smoothly. So this is good work done all around, and this is going to be ultimately very helpful to Minnesotans that we get this included.
All right, thank you, Senator Kent. Let's move to local government. I believe we have Ms. White that can take some or provide us some comments about that portion of the bill. Ms. White, are you there?
Just trying to get activated here. Hi, Mr. Chair and members. Yes, Article 1, Section 1 amends the open meeting law and specifically the conditions that must be met in order to have a meeting conducted by interactive television. Language is added requiring that votes be conducted by roll call so that each member's vote on each issue can be identified and recorded. Also, an exemption is added, the condition that a member's location be open and accessible to the public. The new exemption is for a member who has been advised by a healthcare professional against being in public for a personal or family medical reason. This exemption only applies when a state of emergency has been declared under Section 12.31 and it expires 60 days after the removal of the state of emergency. There's a cumulative cap of 3 times per calendar year that a member may participate from a location that is not accessible or open to the public, which applies to both the new exemption and the existing exemption for members in serving in the military. And this section has an immediate effective date.
All right, are there any questions for Ms. White? Okay, I don't see any. We've got Senator Pratt, go ahead.
Thank you. I had a couple of questions. So does this pertain to the legislature as well, or are we just talking about school boards, city councils, those types of?
Mr. Chair and Senator Pratt, this only applies, this does not apply to the legislature. That's a different chapter of law.
Okay, thank you.
All right, I have Gary Hill, Board Chair of Minnesota Coalition on Government. Go ahead. Are you there, Gary Hill?
Yes, I am. Thank you, Mr. Chairman and Senators. I'm Gary Hill, Chair of the Minnesota Coalition on Government Information. Our organization endorses the open meeting law language found in Article 1 of the COVID-19 response bill at lines 122 through 2.23. This language amends Minnesota Statutes 13D02, one of the 3 remote meeting provisions of the open meeting law. Importantly, this language includes a roll call provision that aligns with the other 2 existing remote meeting provisions in Minnesota's open meeting law. Having a roll call requirement in 13D02 will ensure that there is a procedural clarity around votes taken using remote technology, and will also ensure the creation of a clear and unambiguous documentary record regarding actions taken by a public body. We believe that a roll call for votes is an important transparency and accountability feature of any meeting that involves remote process. And so we support the language in the Senate bill that is currently under discussion. Thank you.
All right, do we have any questions for Mr. Hill?
Yep.
Yeah.
Paul,
Senator.
yeah, Paul, thanks. It's a question, maybe it's for Mr. Hill or maybe it's for Ms. White or whoever was involved in the discussions. I agree with the importance of the roll call vote. I'm curious where the limit of 3 occurred, because if the emergency lasted for many months and so on, a body that has a monthly meeting, I just wondered, I'm not expecting us to have more than 3, but I just wondered where that 3 came from. If that was Minkoji or who was concerned that we limited that.
So Mr. Hill, do you want to try to answer that first?
I can't answer for certain what I'm actually kind of subbing for another board member today, so I wasn't present with the formation of that language. Perhaps Senate Council would know.
Yep. Ms. Stengel?
Mr. Chair, remember, this is Joan White. Actually, the 3 times per year cap is existing law.
That was, Madam, Mr. Chair, was that for the military folks could only do it 3 times in a year?
Mr.
Ms.
Chair,
White?
Senator Marty, that's correct.
Thanks.
And sorry, Ms. White, I was looking on the wrong page.
No worries.
Yep. All right. Any other questions? I don't see any other questions. Well, at least we had an opportunity to have the bill discussed and testifiers ahead of time. I'm glad that we have the language out to the public to see. And so just want to thank everybody for participating. We'll keep, well, after Tuesday, we'll see what direction we go. But I do appreciate Senator Latt's comments about let's have more committee hearings. We'll do them with Zoom. I believe we've started to put out the plan about how we'll do that. And we'll all continue to work together as we battle COVID-19. So I want to thank everybody for participating and have a good day, and we'll see you tomorrow. I'm signing off.
you.